I think for us it's not about power, being powerful or not powerful. I think it's about, can you be able to execute your mandate? And I think for us, the old law, the current law, does not affect how we execute our mandate. So we are fine. The other aspect in this new law that's different from the other one is that we were involved in what is called formulation of what to be privatized. If you look at formulation, which is really the identification, it is largely a policy issue. You cannot be a policy maker and an implementer at the same time. So that separation of responsibility, which shows like what accountants would call segregation of duties, has happened, because then you have somebody else determining what you need to privatize, and then you are involved in implementing what has been approved for you to implement. So for me, this is a really welcome change in terms of the law, and that we are now involved in the implementation of what has been approved, which has the input of the public. The privatization process is more or less a standard process. You start from due diligence, and then there is a process where it reaches where you seek approvals from the respective parties. So prior to this new Act 2023, what we call privatization proposals used to go to the National Assembly. But with the new law, it is terminating at Cabinet. And therefore, in terms of the process, it has been a little bit shortened. If you look at the old law in terms of what is called a privatization program, which is basically really the list of what you want to undertake for privatization, it used to terminate at Cabinet. But this time around, it has gone to Parliament. And in our own assessment, I think that one is even better, because Cabinet is not the only authority now that is determining what needs to be privatized. It is going to the National Assembly, which is really the spokes, the representative of the people, as it were. So the identification, and it also undergoes an element of public participation. So in our own assessment, I think this one, it's complying with the provisions of the 2010 Constitution, where before you determine what you want to privatize, you have to involve members of the public. And also the National Assembly is involved, which was not there before. So in our own assessment, I think this law has actually given the oversight authorities the powers that they required. Why would I have a problem? They are politicians, so if they do their politics, what is the problem? Because that is what they are elected to do, isn't it? So on our part, and you see this is what we are talking about, if we can clarify. You see, what we are saying, Parliament is involved in the determination of what to privatize. So this thing of somebody saying, why have you picked this one or the other? They are the people's representatives. Before even an entity is put in a privatization program for privatization, public participation is involved. So Kenyans will have given their views whether they want this entity to be privatized or not to be privatized. And on our part, we will wait. We don't want any process to be rushed. So once they decide and say A is now for privatization, now that becomes our baby. So we start our process. And the privatization process now includes, going to, like say, for argument's sake, they had assumed that Nation Media was one of the public entities for privatization. So the moment we've been given Nation Media as one of those, so what do? We come and assess the financial health of that institution. We come and look at any legal issue that may affect the process of privatization. We look at are there any outstanding issues that may have. So then based on that information, then we come up with what is called a proposal. Now that proposal also determines what would be the recommended method of privatization based on the facts on the ground with respect to that assessed entity. And then we do what is called a proposal. And then from there, we pass it through our parent ministry, which is the National Treasury, and they will do a cabinet memo, take it to cabinet, with the recommendation that we've had, which is done in a very professional way. The cabinet will look at it, and if they are satisfied, they give their approval. And you know, the approval of that includes even the method of privatization. So the next thing we come and do is to implement. If, say, for example, this is an entity that meets the requirements of capital markets, and we need to do an IPO, we will now look at what are the requirements of Capital Markets Authority for you to have an IPO in place. So all those procedures that are required, we will do. And when that time now comes, we'll offer it in the market, and we invite Kenyans. So depending on what recommendation and what cabinet does, ours is to implement what has been approved. And we are good at that. It is the financial health of that institution. If that entity, for example, has been making losses, you cannot take it to the stock exchange or securities exchange, because you must have had consistency in terms of profitability over a period of time. So there are conditions that you must meet for you to float shares for a company. If it has been making losses, and you think that what this company is lacking is in terms of maybe equipment, maybe it is using outdated equipment. Maybe when people are in this, they are still operating in this because they didn't get any allocations from Treasury or wherever. Then it may require that probably you may consider getting a strategic investor. You can also do what is called sequencing, where you don't do 100% privatization. You can recommend, say, 51%. Maybe after this period of time, especially if it's not profitable. Once it is able to reach this particular stage, when the company probably would have gotten better because somebody has put in money and you can get better value, then at that particular stage, when the business has grown and is better, you can go to the second phase, where then Kenyans can be able to get value. Remember also that some of these, or all of them, will always be companies. So they are also constitutive instruments, like the Articles of Association. So it is a provision in the Articles that says that existing shareholders has the first right of refusal. We must comply, because that's what the constitutive instrument of that particular company is. And in that instance, we will give the first opportunity to existing shareholders to exercise their rights. If they feel like we don't want, then the next stage is now to open up to everybody. So we must always comply with the law and the provisions. And because these are companies, again, we are guided by the Articles of Association or even the provisions of the Companies Act. Let us say this particular company is based in some region, and people within that particular locality feel that this is ours. As many of people have said, this is our ancestral land, or as it were. If we were to do, for example, the IPO, we can, in what you call privatization options, propose and recommend something to Cabinet through the Cabinet Secretary of the National Treasury and say, because these people have this attachment to this, we recommend that probably they're given 30%, for example, of the stake in that. They can come up with either coming up as cooperatives. If we are talking about floating it in the stock exchange, it will be open to everybody, and we can actually limit and say, up to this particular level, give the hustlers or the people within that particular region. Give them priority. If they don't subscribe fully to what they have been allocated, then from there, you give it to the other people. So all these things, because we do due diligence, we also listen to what people are saying. And so when we are coming up with what we call privatization proposals, we take into consideration, and we even give alternatives. We can say, based on this is the feeling of the people on the ground, these are the particular issues, our recommendation would be this. So it's up to Cabinet at that particular moment to be able to consider or even recommend otherwise. And for us, we give a professional opinion, and the approval is granted by Cabinet, and after that we implement what has been approved.